is the First Judicial District Court, Division 7, sitting in Santa Fe, criminal cause D101CR 2015-478, State of New Mexico versus Dianna Duran. Appearances, please.
Good morning, Your Honor. Claire Moran and Zach Jones for the state. Good morning, Your Honor. Erlinda Johnson on behalf of Dianna Duran, who appears before the court.
Good morning. Counsel, you ready to proceed?
State is ready, Your Honor. The defense is ready, Your Honor.
We're on for sentencing this morning. The court has received an objection by defense counsel as to the amount of restitution, and so I think we should start with that issue.
Your Honor, I think we can address that in short order. I have, may I first like to?
Please.
Your Honor, at this time, the defense will withdraw its objection. I have discussed the matter with my client. She would like us to withdraw the objection. The defense agrees that the restitution amount should be $13,866.80. The only issue that I want to point out to the court, and obviously we will defer to the court on whether the restitution should be paid. Obviously we have identifiable victims, $1,050 worth. And the remainder, Your Honor, we will defer to the court whether you order Ms. Duran to pay it to the state treasury or perhaps some other charitable organization, simply because of the dissent in State versus Hernandez and the language of 3117-1A that indicates that when the state is not a victim, the state should not be paid. However, we will defer to the court on that issue.
Ms. Moran, anything else on that issue?
Yes, Your Honor, thank you. In accord with the state's memorandum on restitution, the state, and pursuant to the plea, which specifically specifies the individual donors or the state treasury, the state is asking that the total amount, we do agree with the defendant, that is $13,866.80 to be repaid. We're asking that $10,516.80 go to the state taxpayers general fund, and that $3,350 go to 9 identified donors as specified in the state's memorandum on restitution. Because it is criminal restitution, we think it is most appropriate, as articulated and as agreed upon in the plea, that it go to the state taxpayers general fund. Your Honor, if I may just reply briefly.
Hold on a second. You said $10,016.80. It's $516.80.
Yes, Your Honor, $10,516.80.
Okay.
Your Honor, the plea does call for that restitution amount, but it also indicates as provided by law. And we simply just want to point out to the court that under the statute 31-17-1, the restitution should be paid to victims, identifiable victims. The dissent in State versus Hernandez is just a matter of what the court orders. We would propose perhaps that balance be paid to a charitable organization, for example, like the Council on Problem Gambling.
Okay. Let's go on then. Do we have a representative here from probation and parole? Okay. Thank you. Just want to make sure there was somebody here. Ms. Moran, the state's recommendations.
Thank you, Your Honor. May it please the court.
I'm sorry, can you come up to the podium, please?
Absolutely. Your Honor, may I approach?
Yes, please.
Thank you. May it please the court. As Your Honor may recall, on August 28, 2015, the state filed its information in this manner, alleging numerous counts of criminal conduct. 56 days after the filing of this information, the parties reached a plea agreement. Under this agreement, the state is asking the court to impose the sentences consecutively for a period of 8.5 years less 4 days. The state has reviewed the pre-sentence report, and it agrees with the recommendation of the pre-sentence report and is requesting that restitution in the amount of $13,866.80 be repaid, $10,516.80 to the state taxpayers general fund, and $3,350 to 9 identified donors as specified in the state's memorandum on restitution. The state recommends a fully suspended sentence so long as the special conditions of supervised probation enumerated in the plea and disposition agreement are imposed. Should the defendant violate the terms of probation over this 5-year period, the state could move to impose the 8.5 years of jurisdiction to be served in prison. The state is requesting a suspended sentence premised on the 5-year maximum amount of supervised probation to include the following. 1. Defendant shall comply with all conditions of supervised probation. 2. Defendant shall not have access to or supervisory control of public funds. 3, defendant shall make full restitution of $13,866.80 to individual donors or the state treasury as specified in the plea and disposition agreement. 3, defendant shall participate in counseling and treatment for gambling addiction, which it appears the defendant has already begun. Defendant shall not enter any gambling or gaming establishment. Defendant shall abstain from drugs and alcohol and be subject to random testing for substances. 7, defendant shall report to probation weekly or as ordered by probation for the total period of 5 years. Should the court impose a suspended sentence as requested, the state asks that Ms. Duran report to the probation authority in Santa Fe as required until probation is transferred to Otero County, if that is what she requests. We request that she go directly to meet with the Santa Fe probation officer today to complete an intake appointment and to arrange for initial travel permit, enabling her to reside in Otero County pending transfer of probation. The state's recommendation to the court is a suspended sentence based on the special listed conditions. The state has agreed to defer to the court regarding the imposition of a conditional discharge or a deferred sentence, leaving such decision to the sound discretion of this honorable court. The state has filed a memorandum regarding restitution to assist in the court's analysis, and we have Special Agent Jennifer Weber from the Office of the New Mexico Attorney General to provide any factual information to the court or to provide rebuttal information if necessary. Thank you.
I do have a couple of questions about the restitution.
Yes, Your Honor.
The $10,516.80, as I understand it, that was money that was transferred from the campaign, either taken out as cash or transferred to personal accounts. Is that correct?
Yes, Your Honor. As listed in the state's memorandum on sentencing, that was individual itemized transactions that could not be traced to a specific donor. There is a table within the state sentencing memorandum, and that goes to the specified individual donors. So that was the cumulative amount of $3,350 to the 9 identified donors. And so the $10,000 was essentially money that was within the campaign account that was then taken out. So of course, that cannot be traced to individualized donors, and that's why we feel it is most appropriate that that go back to the state treasury, the state general fund.
Understanding that it would be a logistic headache, could a pro rata amount be returned to all of the donors that gave money from the relative time period, which would have been 2012, 2013?
Yes, Your Honor. That would be appropriate if that was what the court deemed appropriate in this case, within the court's discretion, to do a pro rata return of all contributors. However, in this case, we feel like that is accomplished by giving it back to the state general fund, the taxpayers' general fund. The reason being the statutory structure for leftover funds in a campaign does have specific tenets of contribution. One is the state taxpayers' general fund. So essentially, that if that money had been left over from the campaign funds, which are now no longer, but had they been rightfully...
The campaign account?
Yes, Your Honor.
No longer exists.
The leftover funds should have been returned to the state treasury.
Were there any funds remaining in those accounts when they were closed that was dispersed or returned?
There was not, Your Honor. It was transferred, one circumstance, and that is delineated in the state sentencing memorandum, to a personal account.
My understanding is from the language in the discussion in the criminal complaint that the Attorney General's office has had access to Ms. Duran's income tax returns.
Yes, Your Honor.
Was this money listed, this $10,516.80, listed as income in any of the returns for the relevant periods of time?
Your Honor, if I may consult with my agent, but it's my understanding that it was not listed as income to Ms. Duran in her tax return. If I have a moment to double check that.
Go ahead.
Your Honor, what I've articulated before the court is correct.
Let me look through my notes. I think those are the only notes I have. Questions for you at this time? Thank you.
Thank you, Your Honor.
Ms. Johnson,
Thank you, Your Honor.
recommendation, suggestion? Well, let me stop before you speak. Is there anything else from probation and parole beyond the recommendations and the information that I received as part of the pre-sentence report?
No, Your Honor.
Thank you. And if you just identify yourself for the record, please. From there is fine, just your name for the record, please.
Melanie Martinez with Adult Probation and Parole.
Thank you. Ms. Johnson,
Thank you. May we approach the left, Your Honor?
please.
Would you like my client to approach as well?
If you're going to argue to begin with, no, and I'll call her up later.
Thank you, Your Honor. Your Honor, as a preliminary matter, we do have a few people who would like to address the court on behalf of Ms. Duran. I know that one of them is somewhat under time constraints. Would the court be amenable to hearing from Senator Bill Scherer first, and then I would be happy to address the court?
Senator Scherer. See you in the room. You come forward, sir.
Thank you, Your Honor. My name is Bill Scherer. I am the state senator from District 1 in San Juan County. And while I am known as a tough-on-crime legislator, I'm here today to speak on the character of the woman that I have known for 15 years. The Dianna Duran I know is a person who's deeply concerned about her home and her home state and the people that live here. I know her only concern as a legislator was about the people of her district. She was a very conscientious legislator, diligently working for the people. I believe that all of her votes were thoughtful and thought out votes. And she was courteous to everybody, even the people who were cursing her at the time. I don't think the court could have asked for a better, or her district could have asked for a better advocate than Dianna Duran. I know as Secretary of State, she was concerned also about the state. She wanted everybody that was eligible to vote once. And I think that's the way our system is supposed to be. And I think that was honorable of her. So the question today is, what is the proper punishment for her? And I would like to point out that she didn't harm anybody but herself. She didn't take anybody's life or risk anybody's life. She didn't take anybody's property or risk anybody's property. She didn't take anybody's rights or risk anybody's rights. She didn't take any taxpayer money. What she took was her own reputation. And she's paid a high price already. She's given up her job. She's given up her 40 years of stellar public service. She's given up her dream of being a public servant. And in fact, she has given up her good name. I believe she violated her own trust. And I believe she's already paid a high price for that. Thank you.
Thank you. Ms. Johnson.
Thank you, Your Honor. Your Honor, I would like to start out by just quoting a little bit from the U.S. Supreme Court's decision in Coon versus the United States, that counsels that every court who is about to sentence an individual should consider every convicted person as an individual and every case as a unique study in the human failings that sometimes mitigate or magnify the crime and punishment to ensue. As the court, I'm sure, is very well aware, State v. Sagata counsels the court to evaluate certain factors when imposing a sentence on a defendant. And those factors are the unusual aspects of a defendant's character, past conduct, age, health, any events surrounding the crime, pattern of conduct indicating whether she is a serious threat to society, and the possibility of rehabilitation. As Senator Scherer has pointed out to the court, Ms. Duran has already paid a very high price. She has come before the court very early on and admitted guilt. She admitted she misappropriated funds from her campaign. But to put this in perspective, Your Honor, I want to point out to the court some of the things that she gave up in doing this. I'm sure the court has had many defendants appear before Your Honor. And how many defendants actually give up what his or her attorney counsels as a viable motion to suppress, where Ms. Duran could have appeared before this court, requested the suppression of all the evidence in this case, as the court heard us talk early on, that the way this investigation began was long before these two fine assistant AGs went to the AG's office. An investigator by the name of Jim Wilson went to the bank, the First National Bank in Alamogordo, and obtained, without a warrant, without a court order, without a subpoena, Ms. Duran's personal financial records.
Ms. Johnson, I'm going to interrupt you. If you want to argue those points, then we should be having a different kind of hearing.
No, I understand.
This is a sentencing hearing. And those arguments were made in one of the letters that was sent to me, and I thought it was inappropriate then, and I think it's inappropriate now. If you want to argue the merits of this case, then we should be having a different hearing. This is a sentencing hearing, and I don't think this is productive.
I understand, Your Honor, but the reason I raised that is because Ms. Duran is such a unique individual, because she didn't want to hear about that. She wanted to accept responsibility, and she did. And that's why, early on, she came before this court and accepted responsibility. This is the woman, Your Honor, that people around the state know. This is a woman who is deeply ashamed of what she did. This is a woman who is deeply remorseful for her actions. Your Honor, I know the court has read all the letters submitted to Your Honor.
That's not completely true. I have read everything that was submitted up through the hearing that we had last week. I gave counsel direction that if they had objection to me reading any of the ex parte letters that were sent directly to chambers or listening to any of the phone calls that they had until I believe I gave you Friday of last week to let my office know. I did not review any of those until this weekend is what I told you I would do, and that's exactly what I did. There have been received in my chambers, my understanding, additional letters and other phone messages since our hearing last week. I had not read any of them, and I have not listened to any of those phone messages. My administrative assistant is doing the same thing she did before, which is logging all of the letters and logging the calls. They're available to you if you're, or to the press, if anyone is interested to read them. But I have not seen any of the letters that were submitted since I handed the packet to counsel last week. So there are other things that have come in. There's one exception, and that was a letter that I was given this morning. I was told that it had already been shared with counsel, and so if you'd like to comment on that letter you made, and I have read all of the letters that were included in your filings, the three amendments, as well as the original letters in the packet that I gave to you last week. So I have not read all of the letters, and I have not heard all of the phone messages. I have only seen and heard what I made you aware of now and what I made you aware of last week.
Thank you, Your Honor. And those are the letters I'm referring to, the letters that were submitted by defense counsel on behalf of Ms. Duran.
Okay.
And we appreciate the court taking the time. But what, Your Honor, I wanted to just briefly point out is that Ms. Duran, as the court knows, was born in a very impoverished family. She was born in a family that taught her the value of hard work, honesty, integrity. She was born in a family that she was required from the time she was 8 years old to work hard at the family ranch. Her public service began when she was 15, and she served the people of this state honorably for many years. And as I'm sure the court has read in the sealed submission that was filed with the court, in the last few years, Ms. Duran has experienced a very traumatic family experience. And it's unfortunate because she let this family tragedy affect her in ways that clouded her judgment. She started going to gaming casinos, and throughout the years, that diversion, that entertainment became an obsession, and then became an addiction. And that's why, Your Honor, she's here before this court. Your Honor, she has, in addition to the letters that were submitted by counsel to the court, Ms. Duran has received many, many cards from people in the state of New Mexico whose lives she has touched. And these are people she doesn't some of which she doesn't remember, some of whom she doesn't remember, and these are some of the cards that she has received, and we just brought a few to show the court. And I just wanted to briefly read just some little snippets from some of those cards, Your Honor, from people. These are not people who are her family members. These are not people who are close friends. These are people she helped when either she was senator, when she was a county clerk for Otero County, or a secretary of state. One of the cards dated the day actually she took a plea. And it says, Ms. Duran, maybe God has something much better planned for your life. Sometimes he has to drop kick us into the direction he wants us to go. You are in our heart and our prayers. Another card says, Dianna, just to let you know, many are thinking of you and your family and hope for the best. Many blessings. Dearest Dianna, you are in our thoughts and prayers through this difficult time in your life. Our family will be here for you. And she also, Your Honor, received messages from people throughout the United States, which was a little surprising. A gentleman from South Dakota called and left a message at the Secretary of State's office, Mr. Robert Simpson, said, would like to give you a message of support. Another gentleman stopped by and said, just came by to offer my support and encouragement. And these are people whose lives she touched, Your Honor. This is the Dianna Duran that stands before the court. Another woman, Pamela Lewis, said, Dianna, I just wanted you to know that you and your family are in my prayers. When the whole world walks out, Jesus walks in. A young woman writes, Dianna, I know you're going through a very dark night, but feel my heart say that I pray for you every night, that God will help you with this problem. Someone who apparently worked with her when she was in the state Senate writes, I'm writing to let you know that there are many people who love you, not because you were a senator or the Secretary of State, just because you are you. Even people, Your Honor, from across the aisle, Democrats, have written letters of support. A gentleman who used to work with Ms. Duran at the State Senate left a little note that said, Dianna, hang in there, we love you, from your old Democratic friend. These are just a few examples, Your Honor, of the Dianna Duran, of people who support and know the Dianna Duran who stands before this court. Your Honor, we ask that the court impose a sentence of probation and grant Ms. Duran a conditional discharge. Ms. Duran has been a passionate advocate and a passionate supporter of the people of the state of New Mexico. One of the things that she recalls most fondly as a state senator was helping people. People would call her up and say, I'm having problems with my Social Security benefits. I'm having problems with some sort of benefit. Ms. Duran would take it upon herself to make those phone calls herself so that this person who called her office would start receiving their benefits. That's the Dianna Duran who appears before this court, Your Honor. Yes, she misappropriated some funds from her campaign. And I think the court knows what happened there. She accepted responsibility, Your Honor. There were some very troubling, dark issues that were the catalyst for this problem becoming worse. Your Honor, when you judge Ms. Duran in the totality of the circumstances, when you look at her character, we ask that you look at the entire person. We ask that you look at her trajectory, her entire life, and not simply judge her by the last phase in her life. She made some very bad judgment calls, and she has paid the price. As the senator pointed out, she's lost her good name. She lost her reputation. She lost her position in state government. Your Honor, we ask that you impose a conditional discharge. And I think Ms. Duran would like to also briefly address the court. And we have some other folks, Your Honor, I believe 4 other people who would like to briefly address the court on behalf of Mr. Rand.
I usually allow defendants to speak last. If you'd like to present the others before that, then I would give the state an opportunity to respond before Ms. Duran exercises her right to allocution.
Thank you. Your Honor, before I ask the individuals who are here to speak on behalf of Mr. Rand, I just want to point out, Your Honor, that one of the letters that Your Honor received was from a Dianna Duran. Ms. Duran was actually one of the victims whose donation Ms. Duran misappropriated. Ms. Duran points out to the court that she has faith that you will consider Ms. Duran's recent illegal activity as a deviation to a character that she has always known to be admirable. And she is one of the victims whose donation Ms. Duran misappropriated. And I'm sure, as the court has noted on page 6 of the pre-sentence report, all of the people, the listed victims whose donations Ms. Duran misappropriated, indicated that they asked the court for leniency. And these are the victims of the misappropriations, Your Honor. We ask that the court consider those and look at what these individuals who know Dianna Duran and have known the Dianna Duran of 35 years of public service have to say about her. They ask the court for leniency, and that's what we're asking the court today, Your Honor. We're asking the court to impose the conditional discharge, supervised probation. Ms. Duran intends to make full restitution as the court deems to be paid, whether to the state or in pro rata form to the donors of her campaign. As the court also, Your Honor, I just want to point out, Ms. Duran, this speaks to the character of who Ms. Duran is. She has obtained full custody and guardianship of 3 young grandchildren who she is responsible for raising. This is a woman who, even as she ages, as she is entering her golden years, continues to give. And that's the Dianna Duran that many people know. And for all those reasons, Your Honor, we ask that the court impose a sentence of probation with a conditional discharge. And Your Honor, the first person who would like to address the court on behalf of Ms. Duran is Linda Gully. She is a businesswoman from Alamogordo who has known Ms. Duran for many years.
Ms. Gully, please come forward. Good morning.
Good morning, sir.
What would you like to tell me?
This is so hard. I think of all the people I know, I don't think that the people in Otero County or I would be more shocked to learn that this was about Dianna. This woman has been such an example to so many women, so many people of integrity. She helps people regardless of what party they're in, just their need. I've never heard anybody be turned away. Dianna's the person that I never worried about because I knew she was doing such an exemplary job. And it just saddens me beyond words that this situation, whatever she did do, I'm not here to speak on that, is going to besmirch the incredible job she has done. And I am so appreciative of knowing her as a person, and she's represented us so, so well. I feel like I'm a pretty good judge of character, and I have forgiven her. Everybody in our Otero County that I know feels the same. We're here to support her and love her and stand by her. I thank you for this opportunity.
Thank you for your comments.
Your Honor, the next person who would like to address the court is Vicki McCormick.
Ms. McCormick? Good morning.
Good morning, Your Honor. When I first heard about this situation in the news and the media, I was absolutely shocked and surprised. And first thing that came to my mind was, oh, that can't be. I know her, and how I know her, well, I still call her Senator Duran. But I worked with her Yeah, well, I worked in the Senate chambers for the Senate chief clerk, and I worked all but 2 years with her and helped her, served her, whatever she needed. And so I'm just here in support. And golly, I know you got to do what you got to do, but your leniency would be much appreciated.
Thank you for your comments. Ms. Johnson.
Thank you, Your Honor. Trish Winter.
Good morning.
Thank you for letting me address the court. I've known Dianna Duran for over 15 years, both as a friend and a colleague. Dianna is the friendliest person I've ever met. She is pleasant and kind to everyone. She understands and treats everyone with consideration and humility. She has never thought she was better than anyone else. In all the years I have known her, I have always felt sincerity and commitment from her for being the best person she can be. I have seen the way she talks with and supports all her staff and how much they like and respect her. No matter whether you were a janitor or the governor, Dianna treated all with respect and graciousness. Dianna isn't perfect. Everyone makes mistakes. But I know her, and I know that she truly has never purposefully done the wrong thing. She has a big heart and a strong ethic and a faithful spirit. Dianna has served the people of New Mexico with honesty, strength, and compassion. I know and understand you have Dianna's fate in your hands. And I will ask you to see a woman who takes loving care of her grandchildren, who is respected by all who know her well, and who has honorably served the public for 36 years. And please rule in her favor. Thank you.
Thank you for your comments.
And the last person, Your Honor, who would like to address the court on Ms. Duran's behalf is Karen Turi.
Good morning.
Good morning, Your Honor.
What would you like to tell me?
First, it's an honor and privilege to appear before you on behalf of my dear friend Dianna Duran. I've had the pleasure of knowing Dianna for more than 30 years. It has been said that great leaders build their lives upon simple principles. I have seen it and am aware of the principles on which Dianna has built her life. Honesty, truth, and courage. Dianna is truly the salt of the earth and has devoted most of her life to serving the people here in New Mexico. Many who know Dianna have witnessed the fruit of her labors and have sat in her shade and even protected by her presence. She and her husband, Leo, are raising their 3 grandsons. I have the highest admiration for them both. They took to task with self-sacrifice and without one ounce of hesitation. They are providing a good, stable, nurturing, loving environment for these children. My heart is heavy at the travesty created through these recent events. I am proud of Dianna for her commitment to her family and to the folks of New Mexico, but more importantly, proud to have worked with her and call her my friend. Thank you, Your Honor.
Thank you. Ms. Johnson.
Thank you, Your Honor. Your Honor, just in closing, I would just like to point out that throughout my time representing Ms. Duran, I have never had a client as remorseful, as quick to accept responsibility as Ms. Duran. We ask that the court exercise mercy, impose probation, and a conditional discharge in this case, Your Honor. And Ms. Duran, I believe, would like to just briefly address the court.
Let me, before she does that, let me see if there's any response from the state. Who will allow her to speak. Ms. Moran.
Thank you, Your Honor. Only briefly, if I may address the court from the table, or would
That's
you
fine.
prefer? Thank you, Your Honor. Per the plea and disposition agreement, the state is recommending the suspended sentence and deferring to the court on the other issues. Our request is, of course, that the sentences be served consecutively for the total period of 8.5 years, with the 5-year maximum suspended supervisory probationary period. We do stand by our previous recommendation for full restitution to the taxpayer general fund or the pro rata return to donors. And I just wanted to cite the statutory authority for that, which is 11929.1A, which does allow the repayment of the remaining campaign funds to the state treasury. Thank you, Your Honor.
Thank you. Ms. Johnson,
If I may have Mr. Duran address the court, Your Honor.
please.
Good morning, Your Honor.
Good morning. Take your time, and if you need some water.
Your Honor, in addition to everything that I said to you in my letter, I would just like to publicly state that I'll apologize to the people of the state of New Mexico, to my family and my friends. And I'm truly sorry. I would just ask, I'm sorry. I would just ask this court for forgiveness of me and see when you close your sentence. Thank you.
Give me a minute. If you want to have a seat for a second, that's fine. Have a seat for a second. Let me update my notes before we continue. As I begin, I want to make a couple of comments to begin with. Judges and courts don't get to speak about cases unless they do it from here, from the bench. We don't return phone calls to the public or the press. We don't engage in conversation with friends or colleagues about ongoing cases. It's inappropriate. The only time a judge gets to speak and address the issues that are before the court is when the court is acting in its official capacity and making decisions, and in this case, rendering a sentence. Sentencing is not an open-ended proposition. It is limited by statute. Every crime created by the legislature, or county commission, or city council all sets out the penalties, or at least the maximum extent of the penalties. The sentencing authority of the court is also controlled by statute, and it sets the parameters for what's available when the court suspends any portion of a sentence. During her comments a moment ago, Ms. Johnson referred to the federal case Kuhn. Kuhn gives direction to every judge to look at every case as unique and to look at the accused and the effects of the crime, not in general or as a group, but unique to that individual case and to the individual crime. In this particular case, the court takes a number of things into consideration in fashioning a sentence that I believe approaches, or at least attempts, to administer justice in this particular case. First, the court looks at Ms. Duran's acceptance of responsibility. The original 65-count criminal information was extensive and covered many crimes over a long, extended period of time. In addition, it looks at the actual plea agreement that was entered into between the parties and the parameters and listens to the suggestion of the state. The state is in a unique position, and by that I mean the prosecution in the form of the Attorney General's office is in a unique position to know the detail of the case. A judge, I do not know all of the issues. I do not know the nature and extent of the evidence that would have been presented at trial. The state, in its negotiations with the defense, has weighed those factors and has come forth and made a recommendation to the court. The court also looks at the defendant personally, looks at the history of the individual, looks at the circumstances under which the crimes were committed, and tries to find an understanding, if not an explanation, for why these things occurred. The court also looks beyond that to the effect of the crime and the impact it has had not only on the individuals but also on the community as a whole. I'm going to introduce some of you to a term that you may have never heard before, and that term is restorative justice. The concept of restorative justice has been evolving over the last 40 years. It is a framework to try and understand and to try and sentence in a way that addresses particularized goals in every case. It goes beyond simple punishment or simple mercy. It's an attempt to articulate detailed goals in how the sentence and the components of the sentence addresses those goals. The components of any criminal sentence are very straightforward and the same. And I combine them into really three categories. One is restitution, and we've talked about restitution this morning. The second is rehabilitation, and the third is punishment. And I will address all three of these as I go through the sentence in this particular case. I'm going to address the case in two parts. I'm going to address counts 1 through 4 as a group, and then 5 through 6 separately because they're of a different nature. Many citizens come before this court with addictions, whether it's alcohol or drugs or gambling. In reviewing the evaluations and reports and getting some of the history of your particular addiction, Ms. Diane, it is very similar to what I see day in and day out. The control of an addiction, the inability to address an addiction destroys an individual's life. It also destroys the lives of the people around them. There are many people that are addicts that are what I call functioning addicts. They get up every morning, they go to work, they do their day's work, they come home and either drink themselves into a stupor or shoot up or go to the casino. I've been concerned about your statements, and even when I read your letter was concerned because it sounded very familiar. Many of your statements follow a pattern of rationalization and excuse that I hear from many addicts. It is very similar. The reason I think that occurs is because people try and make sense of their behavior. They're trying to understand it and trying to put it into context, and they minimize it. They minimize the effect it has on them personally, and they minimize the effect it has on everyone else around them. I'm going to deal with the easiest of the three components first, and that is restitution. The court orders that $13,866.80 be paid in restitution. $1,050 to the identified individuals whose campaign contributions were diverted. 9, that would include MAC Energy, the 2,300 amount as well, and all of that money will be returned to those individuals. You will write a letter of apology to each of those individuals, and you will deliver it in person. The balance of $10,516.80, which was converted from campaign funds to your personal use, it cannot be easily traced back to any individual contribution, will be divided pro rata between your contributors over the relevant time period. And you will write a letter of apology to each of them. The next topic I would like to go into and discuss and describe the court's order is rehabilitation. Under the framework of restorative justice, rehabilitation is broader than simply helping an individual try and address the problems that led to their crime. Rehabilitation is also a way of restoring at least some modicum of balance between the individual and society as a whole. The first requirement of rehabilitation as part of the portion of this court suspended sentence is you will continue counseling and therapy with Dr. Agolio. I know it is very difficult for people with addictions to maintain their sobriety if it's a chemical addiction, or in your case, to refrain from engaging in gambling. This court has dozens, if not hundreds, of people on probation and conditions of release on electronic monitoring. The court orders as part of the suspended sentence that you will be on GPS electronic monitoring for the next 3 years. Exclusion zones will be created around every casino, racetrack, and other gambling establishment in the state of New Mexico. And you are prohibited under this sentence from entering any of them unless approved for a particular purpose by your probation officer. The next component of your rehabilitation is to write a letter to the people of New Mexico and apologize for your conduct. You will cause that letter to be published in no fewer than 6 publications of general circulation throughout the state, and those would be divided by region so that the entire state has coverage. Let me back up for a second and say one other thing about the electronic monitoring. If you have had no violations of any of the conditions of your probation for a period of 2 years, you may, by motion, request that the 3rd year of your GPS monitoring be lifted. The next component of rehabilitation is community service. The court orders that over the next 5 years, you perform 2,000 hours of community service. That's 400 hours a year, approximately 30 hours a month. You will donate your time and labor to approved charities within whatever community you are living. You will not be compensated for it. You are not allowed to raise funds or control any money for any of those organizations. rehabilitation, but I'll come back to that in just a moment. I'd like to discuss the 6 counts for which you have pled guilty to individually. The first 4 counts of the plea are fairly common. Embezzlement and money laundering. These are economic crimes. There were specific individuals that were harmed as a result of those crimes. Because of the amounts involved, 2 of them are felonies, counts 3 and 4. For those 4 counts, the court imposes the following sentence. As to count 1, the court imposes a sentence of 364 days and a $1,000 fine. As to count 2, the court imposes a sentence of 364 days and a $1,000 fine. As to count 3, the court imposes a sentence of 1 year and 6 months and a $5,000 fine. And as to count 4, the court imposes a sentence of 3 years and a $5,000 fine. The court suspends at initial sentencing only the jail or prison time associated with each of these 4 counts. The next 2 charges are very different than the first 4. They are not charges that the average citizen faces because the requirements that create them are not common to the average citizen. They are unique charges related to candidates for public office. The reporting statutes require candidates to disclose to the public and to file the source of the funds that the campaign receives and how the candidate spends the money. In these reporting statutes, a right is created for the public. It's an important right. This right is one of transparency. The public, in exercising its civic responsibility in electing public officials, has the right to know where the money comes from. There is also a limitation on how candidates can spend money that is donated for a political campaign. There's actually a list. Personal expenses and gambling debts are not on that list. The harm associated with these 2 crimes is also public in nature. It affects public confidence in their elected officials individually and also in the offices that they hold. Ms. Duran, you wouldn't be here if you had been probably a candidate for City Hall or for some county position. The reason you were here is because you were entrusted by the people of the state of New Mexico to enforce the campaign laws. And that is a portion of the crime that you have committed. Again, going back to my discussion earlier of restorative justice, rehabilitation under that concept or that paradigm is broader. It attempts to try and address the damage that has been done. And you were in a unique position to address that. We've had a number of public officials in the last several years who have been convicted or pled guilty to criminal offenses. Your offenses are different than those in one way. and that is the others all involve public monies of some sort. Your crime involves the embezzlement of private funds, funds donated to your campaign that you converted to your own use. Although you stole the money from these individuals, the damage it created is much broader. The previous elected officials I described a moment ago have all been sentenced. They've all done at least some jail time. But they've also slipped back into anonymity, except for a case like this where another public official is charged with something. We don't hear about them. For many other types of crime, we have programs addressed to try and restore the balance between the community and the individual. For DWI charges, we have victim impact groups. For domestic violence cases, we have domestic violence classes, batterer intervention programs. But for this type of crime, there is nothing in the law of its equivalent. Today we're going to remedy that defect. As a condition of your rehabilitation, you were required over the course of the next 3 years to give at least 4 public appearances per month. You will speak to schools. You will speak to civic groups. In these presentations, you will discuss your life, the service you have provided to the state, the crimes you have committed, the effect that those crimes have had on you personally, and the broader effect that they have had on the community as a whole. At least 1/4 of these appearances will be in an educational setting. Junior highs, high schools, colleges. You will speak to students about government. You will speak to the students about how your life's pursuit of a career in government was cut short. This requirement, I believe, does 2 things. One, I believe it to be part of your rehabilitation. 2, I believe it's a start in restoring the faith that the public has in the office of the Secretary of State and in the other candidates who seek public office. I'm now going to address counts 5 and 6. For count 5, the court imposes a sentence of 364 days and a $1,000 fine. For count 6, the court imposes a sentence of 364 days and a $1,000 fine. As to counts 1 through 4, the court suspends all of the underlying time, which is a total of 6.5 years less 1 day. As to counts 5 and 6, the court suspends 334 days. The court imposes a fine totaling $14,000, 30 days of incarceration, and 5 years of supervised probation under the terms that I have described. Is there need for clarification of the court's judgment and sentence? Ms. Moran is going to prepare the order, so I'll allow you to go first.
Do you have a moment, Your Honor?
Yes.
Your Honor, just 2 points of clarification. One, we just wanted to clarify that all of the sentences are going to be served consecutively.
Counts 1 through 4 run consecutive to each other. Counts 5 and 6 run, let me start over and say that again. Counts 1 through 4 run consecutive to each other for a total of 6.5 years less 1 day.
Thank you, Your Honor.
Counts 5 and 6 run concurrent to each other, but consecutive to counts 1 through 4. So the total sentence is 7.5 years, with all but 30 days suspended.
Thank you, Your Honor. I would just inquire as to the court's order as far as incarceration imposing the 30 days. Is the defendant to be remanded today, or is it the court's intention?
Speak to Ms. Johnson about that in just a second.
Thank you, Your Honor.
Please have a seat. Ms. Johnson, need for clarification on the court's order.
Well, Your Honor, we would respectfully request, I know that as part of the condition of the plea, that if the court were inclined...
Hold on a second. Let me describe something and describe the procedure. Ms. Johnson, or Ms. Duran, excuse me, I order you to surrender yourself Friday morning at 9 o'clock to the Sheriff of Santa Fe County at the Adult Detention Center on New Mexico 14. Ms. Johnson, hold on. You have until noon Wednesday to decide whether or not Ms. Duran is going to move to withdraw her plea. 2 provisions of the sentence, the fine of $14,000 and the 30 days of incarceration, go beyond the recommendation of the state. At the conclusion of this hearing, the court will prepare 3 orders. The first is an order of remand. If I do not receive from you by noon on Wednesday a motion to withdraw the plea, the court will sign the order of remand and will await the final judgment of the sentence to be circulated and presented to the court. If by noon on Wednesday, if you do file a motion to withdraw, the court will issue the second order, which vacates this sentence and reinstates the 65-count amended second criminal information. The court will also issue at that time an amended scheduling order, resetting this case for a preliminary hearing, essentially taking us back to where we were on October the 22nd. Ms. Johnson.
Thank you, Your Honor. With regard to the motion to withdraw, I will address that obviously with Ms. Duran, but with regard to the sentence that was imposed, Your Honor, we would respectfully request that should Ms. Duran accept and not wish to withdraw her plea, we would respectfully ask that the court allow her to self-surrender after the Christmas holiday. Your Honor, she does have 3 grandchildren she is taking care of and raising, and we'd ask that she be allowed to spend the Christmas holiday with them. And also, Your Honor, we would respectfully request good time be authorized on those 30 days. And would the court, with regard to the GPS component, would the court allow that, because again, the fact that Ms. Duran is responsible for raising these 3 young boys, that the court allow probation to, sort of a discretion by probation to confer with the court, as opposed to 2 years, but leave it essentially at the discretion of probation to come to the court before the 2-year period to terminate the GPS component of the sentence. And with regard also, Your Honor, to the fine, because Ms. Duran does have to pay restitution, would the court consider suspending the fine as well? This is quite a financial burden in terms of her means and her ability to pay this fine. Since what we want obviously is to make the victims whole, we'd ask that the court obviously impose the probationary period, the restitution, but with regard to the fine, perhaps either consider decreasing that fine or suspending the fine as well, Your Honor.
let me address each of those points. As to the request that somehow probation have discretion over the GPS monitoring, that's denied. My understanding of the facts in this case is that it was pressure, anxiety, stress that caused an interest in gambling to explode into a full disorder. Those stresses won't go away as a result of where we are today. So the request to modify that or to give authority to the probation and parole department is denied. She will bear the expense, if there is one, for the per diem for the device itself, and also must complete successfully 2 years of probation without any violations of her conditions of probation before she can petition the court to vacate the 3rd year. As to the request to suspend the $14,000 fine that's imposed, counts 1 through 4 are economic crimes. That punishment, and punishment is the 3rd component of sentencing, is directed directly at the economic damage that was caused, and the court imposes the entire amount. The restitution, the order should read that the restitution should be paid first, and then the fine paid, but both have to be completed within the 5-year period of probation.
Your Honor, may the state be heard as to one minor issue?
Let me finish her questions and then I'll come back to you. The 3rd request, which was actually the first one that she made, was a request that she surrendered herself before or after the Christmas holiday and that she be allowed good time. Both requests are denied. Almost without exception, every adult defendant that appears before this court has a family. And the sentence will run from December the 18th at 9 a.m. and she would be released, which is this Friday, and would be released Sunday, January the 17th at 9 a.m. to report immediately to adult probation and parole. Her probation will initiate in Santa Fe County and may be transferred to her county of residence. Ms. Moran.
Thank you, Your Honor. I just wanted to note the state's objection to allowing the defendant the opportunity to withdraw the plea. Based on State v. PRA 2009 NMSC 019, the defendant is not entitled to withdraw her plea. PRA held that the court is not required to afford the defendant the opportunity to withdraw a plea when it rejects a sentencing recommendation or a defendant's unopposed sentencing request, so long as the defendant has been informed of the sentencing recommendation or request is not binding on the court. That case was decided by the Supreme Court of New Mexico and is applicable here. The state and the defendant never bargained for a specific probationary sentence. This was left to the discretion of the court. It has always been contemplated by the court that it could impose incarceration, and that was the plea that was negotiated by the state in this case. The state is simply recommending a suspended sentence based on the specific tenets of supervised probation. There is not a specific sentencing agreement in this case or an agreement as to probation. All that we have agreed to was a non-binding recommendation on this court, and under State v. PRA we object to giving the opportunity to the defendant to withdraw the plea. As specified in the plea and disposition agreement, page 2 and 3 specifically articulate that there could be incarceration and a fine imposed. So that is the state's position.
Let's talk about that for a second. When we were here on October the 23rd, the court rejected the original language of the plea because it was, in my view, ambiguous. The state cannot offer with one hand and then take with the other in negotiation terms and conditions. An individual citizen who is waiving their constitutional protections in exchange for a plea should have a clear idea of what the state's recommendation will be. I have exceeded that in this sentence. And as I mentioned on the 23rd, this was a drafting error. It originally began with what I described as passive language, where the state was not opposing was the language used, and the practitioners that appear before this court on a regular basis know that I will not accept that kind of language because it is ambiguous and it creates expectations And quite frankly, it's not fair. The drafting of the agreement was also not open-ended. The state did not come in the defense and say, you have a range between a conditional discharge and 8.5 years. With all of the contingencies, and particularly the 5 requested conditions, special conditions of probation, and if I haven't already said it, the court adopts all of those conditions plus the other 5 recommended by the Adult Probation and Parole Office as part of this sentence. The first of those conditions is that Ms. Duran has to follow all of the terms and conditions of probation. She has to do that anyway. That's a standard condition, not a special condition. So as soon as that's imposed, it triggers the language of your plea agreement, and I believe creates the conflict that I have described. In this particular case, I tried to make clear when we were here on the 23rd that if the court did impose a jail sentence, the defense would have the opportunity and the court would grant a motion to withdraw it, and that is exactly where we are.
Thank you, Your Honor. I understand the court's interpretation. I'm simply citing to the language within Pieri that a non-binding recommendation does not create that specific sentencing agreement in a case. It is our read of State v. Pieri that we do want that noted objection to the withdrawal of the plea based on the plain language of Pieri and also the plain language of the plea and disposition agreement. Thank you, Your Honor.
And I understand your position, and I respectfully disagree. Ms. Johnson.
Just to briefly point out, Your Honor, page 4 of the plea agreement states, if the court finds the provisions of this agreement unacceptable after reviewing it and any pre-sentence report, the court will allow the withdrawal of the plea and this agreement will be void. It's plain and simple. It's a benefit of the bargain. The AG's office, this is part of their contract, has bargained that away. And Ms. Duran maintains that right, and we will notify the court by Wednesday whether or not Ms. Duran intends to file a motion or proceed with a request to withdraw the plea agreement.
And in response, Your Honor, if I may, since accepting the plea, there's been no aggravating factors that would otherwise change the court's perspective from when it accepted the plea. The PSR, after an exhaustive inquiry as to the facts of the defendant's conduct, came to the same juncture as the parties when the plea was crafted, namely the probated sentence and the suspended recommendation. So I do not believe that under the language that Ms. Johnson is citing that that would qualify for withdrawal of the plea.
Well, depending on Ms. Duran's decision, we may continue this discussion. Ms. Duran, would you please rise? Ms. Duran, you've asked this court for the opportunity to rehabilitate yourself and to make amends for the transgressions and the harm that you have caused. That opportunity is standing before you. It starts Friday at 9 a.m. when you walk through the front door of the Santa Fe County Detention Center. And it ends 5 years from now when the court issues an order allowing you to be free of supervision from the Probation and Parole Office. We're in recess. The court will reconvene at 11 o'clock.
All rise.